Orji. I'm a trial attorney with the Office of Open Government. Okay, so the first act we are going to cover is the Sunshine Act. Today, I'm going to talk to you all a lot about the historical context of a lot of the three transparency laws, kind of give you some legislative intent behind the laws. Okay, so in 1976, Congress passed the Federal Sunshine Act, which is codified in 5 U.S.C.S. Section 552B. The legislators believe that the government is and should be the servant of the people, and it should be fully accountable to them for the actions which it supposedly takes on their behalf. So I think it's important to kind of understand what was going on in the world when the Sunshine Act was passed at the federal level. This was pretty much a response to the Nixon presidency and Watergate. The public was really concerned about the lack of government transparency and the lack of government accountability as a result of Watergate. So in response to that, Congress passed the Sunshine Act in 1976. The Sunshine Act states that every portion of every meeting of an agency shall be open to public observation. This mandate applies to the collegial bodies that head up federal government agencies, so it applies to all federal government agencies. And the Act does recognize that there are circumstances under which open meetings do not serve the public good. So the Federal Sunshine Act does allow for exemptions for closed meetings or closed sessions. Some examples of those are where the content is likely to lead to accusations of criminal behavior, where the content may constitute an unwarranted invasion of personal privacy, the meeting may endanger the safety of law enforcement, or if there is information that will reveal or disclose a trade secret. Those are some of the examples under the federal level where agencies may have closed sessions or conduct closed meetings. Okay, so in that same year, the District of Columbia passed its own Sunshine Act. This is DC Official Code 1-207.42. This is an active statute. It states that all meetings, including hearings of any department, agency, board, or commission of the district government, including meetings of the Council of the District of Columbia, at which official action of any kind is taken, shall be open to the public. No resolution, rule, act, regulation, or other official action shall be effective unless taken. I see a comment here that you cannot hear. Can everyone hear me? Somebody commented and said they could not hear. I am on. Can you hear me now? Okay. Everyone can hear? Okay, great. So like I stated before, all meetings should be open to the public, but these meetings are where official action is taken. Subsection B creates a public right for a record of the meetings. So subsection B states a written transcript or a transcription shall be kept for all meetings and shall be made available to the public during normal business hours. Copies of such written transcripts or copies of such transcripts shall be available upon request to the public at a reasonable cost. So as you can see here, subsection B is not in the federal statute, right? So the DC Sunshine Act does create a right for the public to have a record of the meeting, of the public meeting, or of the agency meeting or the department meeting. And it's at a reasonable cost. The one thing that the Sunshine Act does not have that the Federal Sunshine Act did were exemptions. There are no exemptions in the Sunshine Act that the agency, board, or commission can use to have either a closed session or a closed meeting. It simply states that all meetings where official action is taken may or shall be open to the public. So under the Sunshine Act, what constitutes a meeting? How is a meeting defined, right? So under the Sunshine Act, the term meeting applies to gatherings at which official action of any kind is taken. This also includes hearings. This is a very broad definition, right? It includes a lot of gatherings where there are multi-member government bodies that take action on a public matter. So while the term meeting seems to be broad in nature, there are a lot of meetings that the Sunshine Act does not cover. It does not cover informal gatherings of officials to engage in deliberations. It does not cover meetings where there are administrative work to be done. It doesn't cover roundtables. It doesn't cover deliberations. There are a host of meetings where public agencies, public commissions, public bodies meet where they don't do anything, where they don't pass any kind of regulation, they don't pass any kind of rule. And those meetings are not covered under the Sunshine Act. It also does not apply to purely social and ceremonial gatherings. I see a question here. Can you explain official action? Yes, I can. And that, I believe, is coming up in the next slide. So I will get to you, Larry. Thank you for the question. So before I talk about what an official action is, let's talk a little bit about what the Sunshine Act did not do. So the Sunshine Act did not impose on the DC government bodies any obligation to give the public notice. So if you remember, the Sunshine Act just states that all meetings where official action is taken can be open to the public or should be open to the public, but it doesn't tell the government bodies how to disseminate that information to the public. How will the public know that these meetings are being conducted? How will the public know where the meetings are being held, right? The Sunshine Act is pretty much silent on those things. The Sunshine Act entitles you to inspect and copy transcripts of the recording, but it does not impose specific notice requirements. So as part of your right to be able to inspect the transcript or get a copy of the transcript of a meeting, it does not provide any guidance on how long a government body is supposed to take to fulfill your request for a transcript. It doesn't have any fee. There are no fees in the Sunshine Act. It's pretty much silent on a lot of the things that provide guidance to DC government bodies on how to make sure that the public has access to their meetings. Okay, so what does the Sunshine Act cover? And this is going to answer your question, Larry, about what is an official action. The Sunshine Act covered an agency, board, or commission meeting where official action was taken. What is official action? Well, the Sunshine Act does not explicitly define official action. So it was left up to the DC Court of Appeals to infer a definition. And they did so in Kane v. District of Columbia. They stated that official action is likened to or synonymous with a resolution, rule, act, or regulation. The court stated that an official action must be a formal action where some legal or dispositive effect takes place, and it is not when there is a pre-decisional deliberation or just any action undertaken in the performance of an official duty. So what does that pretty much mean? It means that any meetings that are deliberative in nature, informational in nature, purely status updates, purely administrative in nature, those are not considered official actions under the Sunshine Act. And so therefore, the public does not have the right to observe those meetings under the Sunshine Act, right? And so again, we talk about some of the issues with the Sunshine Act. This was a huge issue. It did not provide a specific definition of what an official action was. And so it was left up to the courts to define it. And it was also left up to the government agencies to carry out or determine what they deemed an official action was. The Sunshine Act does give the public a right to a recording of an agency, board, or commission meeting. And the Sunshine Act does create an inferred private right of action, okay? This is very important. The Sunshine Act does not explicitly provide the public a private right of action, but it is inferred. And it is inferred in the Open Meetings Act. Later on in my presentation, I'm going to talk to you about the Open Meetings Act in greater detail, but I will let you know that the Open Meetings Act does infer a private right of action to the public in their statute. And that is seen in DC Official Code 2-579A2. And that is the inferred private right of action that I'm discussing. So what does the Sunshine Act not cover, right? We talked a lot about the act does not cover any meetings where there is any decision making, status updates, or deliberations. The Sunshine Act did not provide any exemptions for having closed session meetings, which was completely different from the federal Sunshine Act that did provide those exemptions. The Sunshine Act does not cover specific public notice requirements or details about the kind of notice. There are no record keeping or meeting recording requirements that the Sunshine Act covered. The Sunshine Act did not cover whether or not telephone, email, or electronic communications can constitute a meeting for the purposes of the open meetings requirement. And the Sunshine Act did not cover whether quorum is required for the meeting to be accessible to the public, okay? So as you can see, there were a lot of legislative deficiencies with the Sunshine Act, right? There were a lot of things that the Sunshine Act did not do. They did not create a public notice requirement. It did not define clearly what official action meant. It did not create a record keeping requirement for agencies, commissions, or public bodies. There were no exemptions in the Sunshine Act where the agencies could use to have closed sessions or conduct closed meetings. There were a lot of things that the Sunshine Act did not do when it was enacted. And so, as a result of this, the Open Meetings Act was born. In 2010, the DC Council considered the bill for the Open Meetings Act. The purpose of the Open Meetings Act was to provide greater transparency into the public officials' decision-making and preserving high-quality deliberation. The bill has had several goals. It was to effectively notify the public when public bodies will meet and what will be discussed. It was to provide procedures to ensure public attendance at meetings. The bill was supposed to enumerate subjects which may be discussed in closed session. The bill also was supposed to establish remedies available if a public body failed to conduct its business. So here you can kind of see that there, just from the purpose of the bill, the Open Meetings Act was meant to augment the Sunshine Act. Provide greater transparency, meaning that the Sunshine Act, even though the legislative intent was to create a more open government, it did not. It ended up being construed very narrowly because of the legislative deficiencies. So the Open Meetings Act was supposed to provide greater transparency into public decision-making and preserving high-quality deliberation. So that's kind of a signal to us to let us know that the Open Meetings Act is likely going to cover meetings that are deliberative in nature, and that the meetings do not have to, official actions do not have to take place in these meetings in order for the meetings to be open to the public. Okay, so let's talk a little bit about some legislative history with the OMA. So the committee members in drafting the OMA wanted the Open Meetings Act to be construed very broadly. That's actually written in the statute. I believe it's the statement of policy that states that the OMA is supposed to be construed broadly and the exemptions are supposed to be construed narrowly. Advocates of the Open Meetings Act described the Sunshine Act as weak and outdated. So again, like I stated before, one of the purposes of the OMA was to augment the Sunshine Act. They wanted to strengthen the Sunshine Act by defining the public notice requirements and establishing a public rights to observe, among other provisions. Most of the OMA provisions were implemented to address the legislative deficiencies in the Sunshine Act. Okay, so what does the Open Meetings Act require? The Open Meeting Act requires that any gathering of quorum where public body members consider, conduct, or advise on public business offer the opportunity for the public to observe. The public must be given proper notice of such meetings and afforded the opportunity to review recordings of public meetings upon request. The OMA is triggered anytime there's a gathering of quorum of a public body, including hearings, roundtables, regular, special, or emergency meetings where members consider, conduct, or advise on public business. A public body does not include the DC courts, the mayor's cabinet, or any ANCs. And so as you can see here, the OMA already is a lot more broad. It's more, the OMA really hinges on whether or not there's a gathering of quorum of a public body versus the content of the actual meeting. And so what you'll see here is that the OMA covers things like deliberations and roundtables and regular meetings, administrative meetings, any place where there's a gathering of quorum of a public body, the OMA is triggered. So I created a chart for everyone to kind of go over these sections of the OMA, and I just created a brief summary of each section. It is in the DC Official Code 2-571 through 2-580. And as I talked about the statement of policy, 2-572, statement of policy, the public policy of the district is that all persons are entitled to full and complete information regarding the affairs of government and the actions of those who represent them. 2-573, I believe, is a direct response to the interpretation and the construction of the Sunshine Act. The legislators put in this provision that this subchapter shall be construed broadly to maximize public access to meetings. Exceptions shall be construed narrowly and shall permit closure of meetings only as authorized by this chapter. Again, like I stated before, the Sunshine Act, even though it was meant to be broad, it was construed very narrowly. And so here you have the OMA pretty much saying that the OMA, this section should be construed very broadly to maximize public access. 2-574 creates a definition section that defines meeting, public body, and the Office of Open Government. 2-575 is the meat and the teeth of the statute. It basically says that all meetings, except meetings that fall under subsection B, shall be open to the public. Subsection B provides exemptions for when a public body can have a closed session. So very similar to the Federal Sunshine Act, where the Federal Sunshine Act provided exemptions, the Open Meeting Act does in fact provide exemptions for when the public body can either enter into closed session or have a closed meeting. 2-576 is the notice requirements. It provides details on when and how the notice of a public body meeting shall be provided to the public. 2-577 are the meeting procedures. This section discusses the public body's procedures when conducting a meeting or when conducting an emergency meeting. It pretty much creates a good guide, some guidance on how the public body is supposed to conduct its meetings or when the public body is supposed to enter into or can enter into an emergency session. 2-578 is the record of meetings requirement. This section provides rules for how meetings are supposed to be recorded, how the meeting recordings are stored, and how long a recording should be preserved. 2-579 is the enforcement provision. This section provides that the Office of Open Government Enforcement Authority, but it does not imply a private cause of action for this violation of the OMA. So like I stated before, the Sunshine Act infers a private cause of action to the public when agency, commission, or board violates the Sunshine Act, but the Open Meetings Act does not do that. The only enforcement authority is with the Office of Open Government, which is our office. 2-580 is the training provision, and it mandates that the Office of Open Government develop a training manual for the public bodies. Okay, so what are some of the differences between the Sunshine Act and the OMA? I've provided a list of differences. As you can see, just from the nature of the OMA, it's way more robust, right? So the Sunshine Act was only one section with two subsections, A and B, but the OMA is 9 sections. The OMA provides clear definitions about what a public body is, what a meeting is. It provides procedures. It establishes procedures for public bodies to issue public notices. It requires public bodies to conduct a public roll call in order to close all or a portion of the meeting. It requires that all meetings be recorded by audio or video. If not feasible, then the meetings must be recorded by detailed minutes. It provides mechanisms for the Office of Open Government to enforce the provisions of the legislation, okay? So these are some of the things that the Open Meetings Act does that the Sunshine Act did not do. And here I created a chart to compare and contrast the Sunshine Act versus the Open Meetings Act. And here you'll see that there are some things that the Sunshine Act does, like imply a clear right of action for private citizens, but the OMA does not, right? The Sunshine Act requires staff transcripts of all meetings to be available upon request by the public. The OMA kind of takes that a step further, and it talks about how long the recording should be kept by the agency, when the recording should be up for public view after a meeting has been conducted. It pretty much, the OMA really does a good job of taking some of the ideas of the Sunshine Act and taking it a little bit a step further and giving guidance to the public bodies. Okay, so was the Open Meetings Act perfect, right? Did it resolve all of the open government issues? No, it did not. So one of the biggest concerns in the OMA was the provision that all public bodies, that allows public bodies to have a closed session to deliberate upon a decision in an adjudication, action, or proceeding by a public body exercising quasi-judicial function. So this was one of the biggest concerns when the OMA was being enacted by open government advocates. It was discussed a lot in the legislative history of the statute that they felt like allowing a public body to have a closed session to deliberate in an adjudication when the public body is acting as in a quasi-judicial function is contrary to the spirit and the letter of the open meeting statute. A lot of the advocates felt that a lot of government bodies fell within this quasi-judicial function, and allowing them to have closed deliberations would contradict the purpose of the Open Meetings Act. There are other states that have allowed the public access to quasi-judicial deliberations, and one of those states is our neighboring state, Maryland. So in Maryland, the public does have the right to access quasi-judicial deliberations. So if you're thinking or wanting to know what's an example of a quasi-judicial function, some of the examples that were discussed in the legislative history of the OMA were the suspension or the whether or not a public body rescinds maybe a liquor license, or if the Public Service Commission is trying to determine whether or not a utility company can raise its rates for the DC citizens. Those are things that where the public body is kind of stepping into the shoes of a court, kind of, and they are being a fact finder, they are investigating, they're taking testimony. All of those things are quasi-judicial functions. And so the deliberations behind whether or not to suspend a liquor license, grant a liquor license, or allow a utility company to raise its rates, those things, those deliberations are not open to the public under the Open Meetings Act, okay? Okay, so our last and final transparency law is the Freedom of Information Act, also known as FOIA. So let's talk a little bit about the federal FOIA historical overview. FOIA was enacted in 1966 by Congress, and it created a legal right of access to federal records. It stated that any person, doesn't matter if this person is a citizen or non-citizen, may file a request for an agency record, and that agency must disclose it unless the document falls within one of the 9 exemptions laid down in the law. So once the Federal FOIA Act was enacted, it did go through there were a lot of amendments to FOIA. Specifically, the amendments in 1974. These amendments in 1974 did in fact narrow the statutory exemptions for document disclosure in FOIA, and it significantly strengthened the enforcement mechanisms within FOIA. It created reporting requirements for federal government agencies, and it established time limits in which to respond to requests, okay? So the federal FOIA law was enacted in 1966, but it went through a series of amendments, one specifically being in 1974. So in 1966, when the US government enacted the federal FOIA law, the Congress neglected to make the district government subject to the law due to a drafting oversight. So as a result, the mayor, Commissioner Walter Washington, persuaded Congress to allow the district to establish a local freedom of information policy. This was embodied in his Commissioner's Order 71-370, which was issued on November 2nd, 1971. We're going to talk a little in the next slide about his Commissioner's Order, but prior to his Commissioner's Order in 1971, there were all other Commissioner's Orders that addressed the local freedom of information policy. That was Commissioner's Order 299.207 and Commissioner's Order 68-11. Specifically, Commissioner's Order 299207 was enacted in 1935. So the interesting thing about this Commissioner's Order is that it was very narrow in scope. If the commission in this Commissioner's Order, if a person that was not a member of the District of Columbia's government wanted to request a document, they had to agree to do two things. They had to agree that the records that they were requesting would not be disseminated to any third party. So that means that if they requested a record and they received the record, they had to keep that record to themselves and not send it to another entity or another person. And two, they had to agree that these records were not going to be used in a lawsuit later to sue the District of Columbia. So you could not use the records that you requested through FOIA or through the Commissioner's Order against the District of Columbia in a lawsuit at a later date. And that was Commissioner's Order 299.207. So Commissioner's Order 71370 was really the groundwork and the framework for what we know about DC's FOIA laws now. The Commissioner's Order provided that if a person made a written request from an agency, that agency had 10 business days to respond unless it had grounds for delay. This sounds pretty familiar, right? So if there were grounds for delay, those grounds for delay were defined as if the records requested could not be located in the course of a routine search and additional efforts are required to locate them, they were allowed to be able to get an extension, basically. The Commissioner's Order created an enforcement mechanism. It established the Public Information Review Board, which would review delays and denials of information by the agencies involved. The review board consisted of 5 members, 3 government officials, and 2 public representatives. And the Commissioner's Order did not provide a right to seek judicial relief of an adverse decision by an agency. So there were some things in the Commissioner's Order that can be seen in our current DC FOIA law. And that really helped shape DC FOIA law. So in 1977, the District of Columbia passed its own Freedom of Information Act, which is seen in DC Official Code 2-531 through 2-538. And this was designed to pierce the veil of administrative secrecy and to open the agency action to the light of public scrutiny. The act gives any person the right to request a document in any form prepared, owned, used, or in possession of and retained by a public body. It's the public policy of the District of Columbia that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them. Okay, so like I stated before, anyone may submit a FOIA request. So in DC, you don't have to be a citizen of the United States. You don't even have to live in DC in order to submit a FOIA request. And there's no central FOIA office in the DC government. Each public body responds to its request for its own records. The agency has 15 days to respond if it is a request that does not request body-worn camera footage. If there is body-worn camera footage requested, the public body has 25 days to respond. If the request generates a large volume of documents, agencies may invoke a 10 business day extension. Sounds familiar and if you remember the Commissioner's Order that we just reviewed, the agencies may invoke a 10-day business extension, but they have to inform the requester of the extension. Okay. There are certain categories of documents in which the public bodies are prohibited from disclosing if the request for documents falls into one of the 14 categories, then the public body may not provide those records to the requester. There are no fees for submitting a FOIA request. However, a public body may charge fees for searching, reviewing, reproducing records as provided in 1 DCMR 408. Okay. So I provided the Office of Open Government contact information. Our office is comprised of my director, Director Nikhil Allen, and our 5 staff members. I provided all of our names here, and I've provided our contact information. If you have any questions about FOIA, the Open Meetings Act, the Sunshine Act, or any other open government questions, please feel free to contact us. I provided our telephone number here and our email address at opengovoffice@dc.gov. Okay, and that concludes my presentation of the 3 DC transparency laws. If there are any questions, I'll be happy to answer those now. Thank you so much for attending this presentation this morning. So let me look to see if there are any questions. Okay, I see one from Rima. Is this PowerPoint accessible after the presentation? Yes, I can provide a link to the presentation after today, if that is if you need it. And Rima, if you want to go ahead and send me your email address, I can just send you one after I finish my presentation this morning. Yes, you can get a copy. I believe that was from Larry. Was that Larry? Yes. Larry, if you want to go ahead and send me your email address as well, then I can send you a copy. Okay, are there any more questions? Seeing any? Sure. Yes, Edith, I see you here as well. I'll send you a copy as well. Thank you guys so much for attending. Okay. Seeing no other questions, I believe people are just putting their email addresses for a copy of the PowerPoint. Seeing no other questions, thank you guys so much for attending, and I hope you enjoy all of the other presentations by my colleagues. Take care.